Why? Miss Ilak?
Para sa akin, sir, is yes po, sir.
Kaya nga, why
Kasi
yes?
parang, sir, pwedeng magbigay ng example, sir.
Yes, of course.
Parang may na-article po kasi ako nabasa that time, sir, na nung naghahanap po kami dun sa may cooperative team pa namin na na yung bylaws po is kasangay din niya po yung suppliers of yung corporations. So, tulad po ng Coca-Cola company, sir, ganun. Kasi parang ina-applicable po nila yung environmental laws po, mga rules and regulations po, ganun. So, compliant po ng applicables ng po, laws and standards, mga ganun po.
Okay, sige. Sige, thank you for that, Miss Ilak. Isa pa. Sino may idea? Isa pa. Mr. Eljan. Mr. Alayban. Mr. Alayban. Wala. Mr. Eljan, nasan? O, Miss Tabangkura, nasan ka na? Nandyan ka na? Buhay ka na? Wala itong mga to ha. Bahala kayo ha. Mr. Lingan.
Sir.
Yan.
Dito, sir. Present, sir.
Sige, narinig mo ba yung question kanina tsaka yung sagot ni Miss Ilak?
Sir, yung question lang.
Sige.
Kaya ba ang bylaws sa mga creditors, gano'n, sir?
Yes. Can I have your answer for that?
Sir, sa akin din, sir, yes. Correct me if I'm wrong lang, sir. Yes, kasi yung bylaws, sir, sa pagkakalam po, ang ibig sabihin niya, loss yun ng isang company community na kailangan sundan or parang gano'n, sir, kailangan sundan.
Sige. Thank you. Sige. Balik tayo dun sa definition kanina. Sabi ko kanina, there are There are three persons concerned. Diba? With regards to rules and regulations laid down by the corporation. Una, for the corporation itself. Pangalawa, for the government of its stockholders or members. And then pangatlo is the board of directors, board of trustees, and also the corporate officers. So yun yung governed or covered by the bylaws. So kung babasahin mo yung definition, nowhere there can you put the creditors of a corporation, the suppliers of a corporation, even the clients or the customers are not there in the bylaws. Because the bylaws are made solely for the purpose of providing rules of action for the corporation to follow. So ang sagot dun sa question ko is no. Third parties or third persons such as the suppliers of a corporation or the creditors of a corporation are not covered by the bylaws. Now with regards to the answer of Ms. Ilak na they complied or they included in their bylaws with regards to formulating environmental awareness in their bylaws, then so be it. But the coverage of that bylaws is only with regards to the corporation. So corporation, stockholders, or board of directors or officers lang ang covered ng bylaws. It just so happened that they adopted external regulations such as environmental laws. Okay? Keep that in mind, okay? Hindi covered ang third persons or third parties with regards to bylaws. Now, let's proceed. the requisites of bylaws. The first one is that it must be consistent with the law and the articles of incorporation. When we talk about the law, we talk about the revised corporation code. Okay, it must be consistent with the revised corporation code, meaning all the provisions of the revised corporation code dapat consistent si bylaws, and also with the articles of incorporation. It must also be consistent with public policy. Okay? So kung consistent siya sa law, consistent siya sa articles of incorporation, dapat consistent din siya sa public policy. Okay? So kahit pa walang law with regards to that bylaws, but it is proper with the public policy, then that should be followed, or yung bylaws mo dapat consistent with it. It must be uniform and general in application. Okay? Kasi bylaws naman siya. Okay, iba pa yung policies ng corporation, which is more specific na in application. It must also be reasonable, of course. If a bylaw is already consistent with the law, with public policy, malamang sa malamang it is reasonable. It must not impair the obligations of contracts, meaning the bylaws cannot in any way affect any contract existing between the corporation and a third party. Okay, so those are the requisites of bylaws. Question: in case of inconsistency with the articles of incorporation, which one prevails? The articles of incorporation or the bylaws? Miss Consul Danica. Wala.
Sir?
Uy, meron. Sige. In case of a sige.
Sige po, sir.
Ikaw na, nalig mo na yung tanong. Sige.
Ay. For me, sir, is mas liable po yung sa corporation po, sir.
No. My question is, in case na may conflict between articles of incorporation and bylaws, ano ang magpre-prevail? Ano ang masusunod, kumbaga? Si articles of incorporation or si bylaws? Hello?
Bylaws, sir.
Bylaws? Bakit? Kasi may law.
Sir,
Ano? Bakit? Miss Danica.
sir, sir, yung dahil bylaws, sir, kasi mas, yun po yung sinusunod ng corporation, like, through services, ganun, sir. So, parang, mas, kapag may mga conflict, sir, mas, ano po ang bylaws, ganun, sir.
Okay, sige. Thank you for that. Mr. Aduro. Mr. Aduro. Oh, saan siya? Parang si Tabangko na lang. Wala. Mr. Liban. Mr. Liban.
Sir,
Oh, sige. Narinig mo ba yung question kanina?
Kung ano po yung mas masusunod, yung bylaws or yung sa corporation.
Yes.
For me, sir, is mag-prevail po yung bylaws.
Why?
Because po sa bylaws po is nandun na po yung rules and regulations and the things that the corporation should follow po.
Okay. So, bylaws ang mag-prevail?
Yes, sir.
Okay, sige. Thank you. Thank you for that. Okay, so balikan natin yung yung first requisite. It must be consistent with the law, referring to the revised corporation code and to the articles of incorporation. So, meaning si bylaws, dapat hindi siya maging inconsistent with the articles of incorporation. Why? Because the articles of incorporation is the document that you are going to file with the Securities and Exchange Commission in order for the SEC to give life to the corporation. So, with regards to matters covered by articles of incorporation, in case na may inconsistency with the bylaws, the articles of incorporation should prevail. Okay? With regards to matters that are outside of the scope of the articles of incorporation, kasi alam nyo naman, discuss natin before, ang articles of incorporation, yung mga matters lang naman na nandyan is those matters that are important as to the creation of the corporation, di ba? Yung office, yung stockholders, ganun lang ang nandyan. Okay? So, kung wala naman sa articles of incorporation, then the bylaws should apply or should be the one prevailing. Okay? So, take note of the requisites of the bylaws. Consistent with the law and the articles of incorporation, must be consistent with public policy, must be uniform and general in application. Meaning uniform, meaning there is kumbaga parallelism sa bylaws mo. Hindi contradicting ang bylaws mo. Uniform and general in application. It must be reasonable. It must not impair the obligations of contracts, as have discussed in your obligations and contracts before. Okay? Dapat hindi ma-impair ang obligations and contracts. Okay, since we mentioned about articles of incorporation, okay, there is the difference between the AOI and the bylaws. Okay, let's take this one by one. When we talk about articles of incorporation, this is a condition precedent in the acquisition of a corporation or in the acquisition of corporate existence. Meaning that these articles of incorporation is a document required in order for the corporation to exist. Okay? Unlike for the bylaws, okay, it is a condition subsequent. Meaning, its absence merely furnishes a ground for the revocation of the franchise. Meaning, the bylaws is not required for you to create a corporation. What is required in order for a certificate of incorporation to be issued by the SEC is that the articles of incorporation must be filed. Yun ang kailangan. Kaya siya condition precedent in the acquisition of the corporate existence. As with the bylaws, pwede mo siyang isubmit after na-create yung corporation or pwede mo rin siyang isabay. I-discuss natin yan later. Okay? The second difference, when we talk about articles of incorporation, it is essentially a contract between the corporation and the stockholders or members, between the stockholders or members inter se, and between the corporation and the state. So, nandun na sa articles of incorporation, lahat ng agreement with regards to the corporation, the stockholders, and the government. Okay? Sinabi natin contract, meaning it is a law between the corporation, the stockholders or members, and involving the government. Okay? But when we talk about the bylaws, it is for the internal government of the corporation. Meaning, ang concern ng bylaws, hindi yung third parties, yung sinabi natin kanina, di ba? Ang concern ng bylaws is the government of the corporation, the stockholders or members, pati yung board of directors or trustees, pati yung corporate officers. But, it has a force of a contract, meaning, it is also a law between the concerned persons, yung sinabi ko kanina. Okay? So, yung isa, Articles of Incorporation is essentially a contract. Bylaws is not a contract but has a force of a contract. Okay? The third one is the Articles of Incorporation is executed before incorporation. Meaning, bago mag-create yung corporation, kailangan mo ng Articles of Incorporation. Yung sabi ko kanina, di ba? But with regards to bylaws, it may be executed after incorporation, di ba? Ibig sabihin, meron na yung corporation, saka mo lang pwede mo ding ipasa yung bylaws. However, Section 46 allows the filing of the bylaws simultaneously with the Articles of Incorporation. Meaning, you can file the bylaws together with the Articles of Incorporation kung sobrang sipag nung originator or yung incorporators nyo. But nonetheless, the general rule is that it may be submitted or filed after incorporation. Okay? So, yun yung titignan nyo na difference ng bylaws and Articles of Incorporation. So, hindi mo kailangan ng bylaws kung gagawa ka ng corporation. Ang importante is merong Articles of Incorporation. Okay? The fourth difference with regards to its amendment. The Articles of Incorporation may be amended by a majority of the Board of Directors or Trustees and stockholders representing 2/3 of the outstanding capital stock. Okay? Take note kapag amendment ng Articles of Incorporation, majority of the BOD and 2/3 of outstanding capital stock or members. Kapag bylaws naman, majority of the BOD or BOT and majority of the outstanding capital stock, hindi 2/3. Okay? So, yung isa, majority and 2/3. Yung bylaws, majority and majority. Okay? As regards to delegation of the power to amend or repeal, the power to amend or repeal Articles of Incorporation cannot be delegated by the stockholders or members to the Board of Directors or Trustees. Remember guys, it cannot be delegated. Okay? Why? Because na-discuss ko na to noon. With regards to amendment of Articles of Incorporation, kailangan involve ang stockholders or members. It cannot be delegated to the Board of Directors or Trustees. Okay? However, for the bylaws, pwede. Okay, so nakikita nyo na yung difference and importance nung two documents natin, yung Articles of Incorporation and bylaws. Okay? The power to amend or repeal bylaws or adopt new bylaws may be delegated by the 2/3 of the outstanding capital stock or the members of a corporation. So the difference, yung AOI, hindi pwedeng i-delegate sa BOD or BOT. Yung bylaws, pwedeng delegate through 2/3 of the outstanding capital stock or 2/3 of the members in case it is a non-stock corporation. So take note of the differences between bylaws and articles of incorporation. Question: when are the bylaws adopted? Sabi ko nga kanina, di ba? Before incorporation or after incorporation. Approved and signed by the incorporation and then submitted together with the articles. Ito yung sinasabi natin kanina, balik tayo. Yung it can be filed simultaneously with the articles of incorporation. Meaning, kapag nag-file ka na at nag-submit ka na ng articles of incorporation kasama na si bylaws. Pwede. But, mas madali na kasi ito para minsanan lang. Especially for those corporations or partnerships established sa Luzon and sa or Northern Luzon or sa Visayas and Mindanao, yung malalayo sa Manila. Kasi nandun yung SEC sa Manila. Okay? And then, they can also be adopted after incorporation. Okay, after incorporation, approved by the majority of the outstanding capital stock or members, then submitted to the SEC. So take note, it can be filed simultaneously, number 1. And then, number 2, it can be filed after incorporation. Okay? However, for the following corporations, SEC will not accept the bylaws for filing if not accompanied by a certificate from the appropriate government agency stating that the bylaws or the amendments thereof are in accordance with the law. Okay, these are banks, buildings and loan associations, trust companies, insurance companies, public utility, educational institutions, and other special corporations governed by special laws. Okay? Take note of that. So, before mo i-file yung bylaws mo, if you are thinking of forming a bank or even a microfinance corporation or an insurance company or public utility company, kailangan may certificate of approval from a concerned agency with regards to banks, BSP, pati yung loans associations, okay? With regards to public utility, DOTR, or Department of Transportation. So they must have, ito na yung sinasabi kanina, i-relate ko din yung sa recitation ni Miss Ilak kanina. Okay, because there are there are corporations that require an approval or certificate from an appropriate government agency before the bylaws will be accepted by the SEC. Okay? And stricto pa naman ang pag-check ng requirements with regards to SEC. Okay? So take note of that. Sir, attorney, ano ba ang laman ng bylaws? Okay, ito. Ang contents ng bylaws. The time, the place, and the manner of calling and conducting regular or special meetings of the directors or trustees. Okay? The time and manner of calling and conducting regular or special meetings and mode of notifying the stockholders or members thereof. This one, itong first two na-discuss ko na nung midterms nyo. Okay? With regards to notice na kailangan andun yung time of the meeting, the place of the meeting. Kung wala nakalagay, probably in the official address or official office or principal office. The manner of calling, diba? It can be served personally, mail, and yung bago na sinabi ko, it can be served through email. But kung email ang gagamitin natin, it must have the prior consent of the stockholders, members, or the directors or trustees. Okay? The third one, the required quorum in meetings of stockholders or members and the manner of voting therein. Okay? Quorum meaning majority 50% plus 1. Okay? Sir, paano kung yung quorum namin ginawa namin 2/3 or 75%? Pwede ba yun? Yes. You can set that high. Okay? But ang quorum is needed in order for the stockholders or members to have a majority decision. Okay? So, okay lang siya na higher siya than 50% plus 1. Okay lang na 75%. But then, under the law, 50% plus 1. You can set it higher though. Okay? The modes by which a stockholder, member, director, or trustee may attend meetings and cast their votes, di ba? By virtue of this pandemic, na ma-magnify yung importance ng revisions na ginawa sa revised corporation code. Because if I don't know if you're aware or nag-advance reading kayo before nung wala pa yung bagong corporation code. Before, wala kang makitang teleconference, wala kang makitang email sa corporation code. Kasi matagal nang ginawa yung corporation code bago yung bagong revision niya. But then, dun sa revision, it already allowed na, sabi ko kanina, yung notice, it can be served through email. Diba? Yung votes or yung meeting, you can attend through teleconference. Diba? These are the innovations with regards to the modes that are introduced in this revised corporation code. And it is highlighted because of what is happening right now, di ba? Very conforming siya, and it really changed a lot of things with regards to face-to-face meetings and conferences. Before kasi kapag hindi ka nag-attend na, hindi na pwede. Okay? And strict to pa ang pag-proxy ng votes. Okay? Speaking of proxies, the form for proxies of stockholders and members and the manner of voting them. So, meron na dun sa bylaws yung form ng proxies. The directors or trustees' qualifications, duties, and responsibilities, the guidelines for setting the compensation of directors, trustees, and officers, and the maximum number of other board representations that an independent director or trustee may have, which shall in no case be more than the number prescribed by the commission. So, ang sabi nga natin noon, if maalala nyo pa, a board of director or board of trustee yung qualification niya. Diba? Kung board of director, kailangan holder ka lang naman ng isang stock, kahit isang stock lang ang hawak mo, pwede kang maging board of director. Kung board of trustee naman, as long as member ka, board of trustee ka. But, you can add sa bylaws. Okay? Pwede kang mag-add ng qualification sa bylaws. Okay? Duties and responsibilities. Okay. And then, the time for holding the annual election of directors or trustees and the mode or manner of giving notice thereof.
Could you try again?
The manner of election or appointment and the term of office of all officers other than directors or trustees. Okay? The penalties for violation of the bylaws, and in the case of stock corporations, the manner of issuing stock certificates. And last, other matters as may be necessary for the proper or convenient transaction of its corporate affairs, for the promotion of good governance and anti-graft and corruption measures. Again, if you read the old corporation code, wala kang makitang anti-graft and corruption measures. Okay? But here, under the revised corporation code, meron. And it speaks of this scenario that graft and corruption does not only happen in the government, in the Philippine government. Okay? The law or the senators and the congressman is aware that there is also a graft and corruption in terms of these high-profile companies. So meron din nangyayaring graft and corruption with regards to these corporations. Okay? Note also that an arbitration agreement may be provided in the bylaws pursuant to Section 181 of the Revised Corporation Code. Meaning, guys, sa inyo, sa personal nyo na buhay, kung naranasan nyo ng may kapamilya kayo o meron kayong relative or kapitbahay na mga nababarangay. Okay? Ganyan din sa corporation. Mas maganda, idaan muna sa arbitration, mediation, or conciliation. Ibig sabihin, pag-uusapan muna bago magkasuhan. So, ganun din sa corporation. So, maganda. Why? Because it helps the court to declog cases, di ba? When there are cases that can be settled, when there are cases that don't need to be filed in court because pwede namang pag-usapan or the parties can meet in the middle, then better na merong arbitration agreement. Okay? Para siyang yung barangay na narinig nyo. Kapag barangay, si ganito, si ganyan, ganun ang dyan sa arbitration agreement. Okay? Pero instead na barangay, depende dun sa arbitration agreement na i-formulate nila, whether conciliation, mediation, or arbitration. Okay? Sige. Those are the contents of the bylaws. Next, the effectivity of the bylaws. The bylaws only become effective upon the issuance of a certification by the SEC that the bylaws are in accordance with this code or with the revised corporation code. So, as long as the bylaws or as long as the certificate from the SEC is not yet issued, the bylaws will not be effective. So, effective lang siya upon issuance of a certification from the SEC. Let's proceed. With regards to amendment, repeal, and adoption of new bylaws, what are the votes required? Okay, with regards to amendment, repeal, and adoption, majority of the Board of Directors or Board of Trustees and majority of the outstanding capital stock or all members. Take note na banggit ko din ito kanina dun sa difference between Articles of Incorporation and bylaws. Majority and majority kapag bylaws. Okay? With regards to delegation or revocation of power to amend or repeal bylaws, ito nabanggit ko rin kanina. With regards to delegation, 2/3 or all members may delegate to the board. Then, majority of the board of the directors or board of trustees shall vote. With regards to revocation, majority of outstanding capital stock or members may revoke the power previously delegated. Okay, so the stockholders can delegate the power to amend, repeal, adoption of new bylaws to the board of directors or board of trustees. Okay, but by virtue of their power to delegate is their power to take away or their power to revoke that delegation. So, yun yung sinasabi natin dito na revocation. Okay? So, ang pag-revocation, majority of outstanding capital stocks or members. Okay? When amendment of new bylaws becomes effective. Okay? Only upon the issuance of a certification that the bylaws are in accordance with this code. Meaning, just like the previous slide, maging effective lang siya upon the issuance of certification. But take note this is an amendment to the new bylaws. Okay? Meaning, hanggat wala pang bagong certificate na inisyo si SEC, ang bylaws na magko-cover or bylaws na effective pa rin is the old bylaws, not the new bylaws. Okay? Let's proceed to the next topic. Saglit lang to. Meetings. Meetings are necessary to deliberate and decide upon corporate acts. So very simple definition, but then again, we're talking about corporate acts. Okay? Sabi natin before, in our previous discussions, there is what we call ultra vires acts and there's what we call intra vires acts. Okay, so meetings are necessary in order to make a corporate act valid and effective, di ba? So kapag hindi rin nag-pursue sa meetings, a corporate act can never pursue or parang hindi siya magiging it will never come into fruition, kumbaga. Okay? So, meetings are essential. They are necessary to deliberate and decide upon corporate acts. So, without these meetings by the board of directors or board of trustees or the stockholders or members, then the corporation cannot act. Okay? Kaya kailangan nilang mag-meet. Okay? And with regards to meetings, there are two groups that we need to consider. The first one is the board of directors or board of trustees, and the second one is the stockholders or members. Okay? We'll proceed first to the first one, the board of directors or board of trustees. Okay? There are two kinds under these meetings. You have the regular meeting and then the special meeting. When we talk about the regular meeting, mostly, ang date dyan is monthly. Okay? Monthly yan. Kailangan mag-meet ang board of directors or board of trustees. Bakit naman, attorney, monthly? Diba? Sabi nga natin before, in our discussion in board of directors, diba? Sabi natin, they are the ones who decide in the operation of the business. Sila yung top management. Diba? That's why they need to meet at least monthly. Or, unless provided otherwise in the bylaws. Pwedeng weekly, pwedeng bi-monthly, kung ano yung decision ng stockholders. Okay? The notice should be given at least 1 day before the meeting. So, hindi pwedeng agad-agad meeting. Okay? Because when you talk about this board of directors, madami din silang engagements. Okay? So, at least 1 day before the meeting, dapat ma-notify sila. Okay? And now, you can do that now kasi pwede naman na ang email. Okay? So, if personal service cannot be affected, then pwedeng email. Okay? Special meeting, anytime upon the call of the president or as provided in the bylaws. Okay? Yan ang anytime kapag special or those that are urgent, certified as urgent, di ba? Kaya kailangan mag-meet. Okay? Take note, in these meetings, kailangan mayroon tayong quorum. Because, if wala din namang quorum at nag-set kayo ng meeting, wala ding corporate act na mangyayari. Okay? That's why it's very important to discuss about the topic meetings. Okay? Notice here is at least 2 days before unless a longer time is provided in the bylaws. So, ang sabi niya, at least 2 days before unless a longer time is provided. So, pwedeng 3 days, 4 days, a week before, pwede. But take note, special meeting kasi ito. So, may urgency. May urgency with regards to this meetings. Okay? With regards to the place, anywhere, unless otherwise provided by the bylaws. So kung naka-provide sa bylaws na sa principal place or principal office ang meeting, then so be it. Okay? The quorum needed, majority. Sabi ko kanina, dapat yung mga board of directors or board of trustees must have a quorum. Let's say a board of directors for corporation A is 15 sila. What's the quorum needed? Okay, the quorum needed there is 8. 50% plus 1, 7.5 plus 1, di ba? 8 ang kailangan to have a majority. Unless a greater majority is provided in the articles or bylaws. Gaya nga lang sabi ko kanina sa bylaws, pwedeng increase to 2/3 or to 75%, pwede. As long as provided siya sa bylaws. Okay? Pero kung wala, majority meaning 50% plus 1. Okay? The presiding officer shall be the chairman, pero let's be gender sensitive. Dapat dyan, chairperson, or in his absence, the president, unless otherwise provided in the bylaws. Okay? So, ang presiding officer for the meetings of the board of directors shall be the chairperson. Okay? Kaso lang kasi, madalas kasi dyan, si president din lang chairperson. Pero hindi naman necessarily na siya. So, you can elect other chairpersons. Okay? The manner of voting, ayan, sabi ko kanina, it can be done physically, di ba? Pwede lang face-to-face, or through a proxy. Kung hindi ka maka-attend, gusto mong ibang magboto sa'yo, you can do that. Or, ayaw mo ng proxy, through video conferencing, or teleconferencing, or other alternative modes. Gaya ng sabi ko kanina, the relevance of what is happening today in the world, di ba? Has really brought changes not only sa atin but sa laws din natin. And isa na dito itong revised corporation code because it already allowed for video con or teleconferencing. Okay, that you cannot find in the previous or in the old corporation code. Note that directors or trustees cannot attend or vote by proxy at board meetings. Okay? Let's proceed to the meetings for stockholders or members. So, dalawa din siya. May regular meeting ng stockholders or members. Meron ding special meeting. Okay? The regular meeting is date fixed in the bylaws. Kung ano yung date fixed in the bylaws. So, it could be any other day. Diba? Every 30th of the month, or every first Monday of the month, or every last Friday of the month, pwede. Okay? Otherwise, any day after April 15th of every year. Okay? Any day after April 15th of every year. With regards to notice, so malayo yung difference niya with regards to the meetings for the board of directors or board of trustees. Dito sa notice niya, at least 21 days before, unless a longer time is provided in the bylaws. So take note, at least 21 days. Compared mo dun sa kanina sa board of directors or board of trustees, 2 days, 1 day lang. Dito at least 21 days. Why? Because these are the stockholders or the members, these are the owners. Okay? Wala sila dun sa corporation yan. Sa araw-araw na business ng corporation, hindi mo sila yan makita. Diba? Nag-appear lang sila dun sa records book, dun sa stocks and transfers book ng corporation. Okay? So most of them are not from Manila, not from the metropolitan areas. Diba? That's why a 21-day notice is required. Okay? Or kung kailangan pang mas mahaba, pwede din as long as provided in the bylaws. So kung 30 days before, pwede din. Diba? Okay? With regards to special meetings, anytime deemed necessary by the word itself is special, diba? Merong element of urgency with regards to special meetings by the stockholders or members. The notice, however, is at least 1 week before unless a longer time is provided in the bylaws. So, 1 week before, pwede rin siyang more than 1 week if provided siya in the bylaws. With regards to place, ayan, ito, kapag stockholders or members, principal office of the corporation as set forth in the Articles of Incorporation. But if it's not practicable in the city or municipality where the principal office of the corporation is located. Okay? So, sa meeting ng stockholders or members, dapat sa siya, principal office of the corporation. So, kung ano yung makita nyo doon sila mag-meet. Okay? The quorum needed is majority of the outstanding capital stock or all members. Okay? Majority of the outstanding capital stock or all members. Hindi mo siya pwedeng iset at a higher quorum. Diba? Unlike dun sa quorum with regards to the meetings of the Board of Directors or Board of Trustees, dito sa meetings of stockholders or members, majority lang siya. Hindi siya pwedeng iset at a higher quorum. With regards to the presiding officer, same as to the meeting of Board of Directors, it's the chairperson who shall preside. Okay? Pero kung wala si chairperson, it's the president unless otherwise provided in the bylaws. So kung wala si president, wala si chairperson, kung nakalagay sa bylaws na si secretary or si Mr. ganito, sila ang magpre-preside. Okay, take note. Dito mo makikita. Wait lang ha. In regards to manner of voting, okay? The first one is physically, of course, if pwede yung face-to-face. Okay? And then, through proxy, if hindi siya present or cannot attend, pwedeng ipaboto niya na lang sa iba. Okay? Take note ha, dito sa voting, ito sa sa corporation ha. Kapag sa election, hindi pwede ang proxy walang proxy. Okay? Election na dito sa atin sa government. Or in absentia or through remote communication. The guidelines to be sent to the stockholders in the notice. So, pwede rin in absentia or through remote communication. So, hindi siya teleconference kasi boboto ka. Okay, boboto ka dyan. Other concepts in voting. Joint ownership of stock. The consent of all co-owners is necessary. Of course, if there, let's say for example, 50,000 stocks of Corporation A is owned by Mr. XYX, Mr. Y, and Mr. Z. So lahat sila doon nagmamayari ng stocks. Meaning, the consent of all the co-owners is necessary unless there is a written proxy signed by all the co-owners authorizing one or some of them or any other persons to vote. Meaning, lahat sila kailangan ng consent kapag boboto. Okay? So, hindi sila pwedeng iba-iba ng i-vote with regards to the meeting that we have just discussed. So, kung si XYZ, owners sila, joint owners sila ng 50,000 na stocks ni Corporation A, they must all consent to the vote. Let's say for example, ang corporate act na subject ng meeting is, let's say for example, to increase the capital stock of a corporation. Okay? Kailangan lahat sila, si Mr. X, Mr. Y, Mr. Z, boboto or magko-consent na ito ang consent, ito ang decision namin, i-increase yung capital stock or hindi increase. Okay? When the shares are owned in an and or capacity by the holders thereof, any one of the joint owners can vote said shares or appoint a proxy therefore. Ayun naman. Take note, kung joint ownership lang, kailangan ng consent ng lahat. But when the shares are owned in an and or capacity, meaning 50,000 stocks are owned by Mr. X and or Mr. Y. Ayan. So, either of them can vote, okay, or they can appoint one as a proxy to the other. Okay? With regards to treasury shares, it possesses no voting rights as long as they remain in the treasury. Of course, if they are in the treasury, they have no voting rights. And the last one, voting trusts. An agreement in writing whereby one or more stockholders in the corporation transfer their shares to trustees for the purpose of conferring in them voting and other rights pertaining to such. Okay, so I'll elaborate this one further. Voting trust. The procedure in the transfer of shares. The certificates of stocks covered by the VTA or the voting trust agreement shall be cancelled. New certificates shall be issued in the name of the trustee pursuant to the VTA. The trustee or trustees shall execute and deliver to the transferors voting trust certificate. Okay? What is the effect of this VTAs or this voting trust agreement? The voting trustee acquires legal title to the share. Okay? Take note, he acquires legal title to the share. Transferors become mere equitable owners of the shares represented by the voting trust certificates. Okay? Yung voting trust certificates, this is issued by the trustees. The trustee votes in accordance with the terms of the VTA. Both transfer and trustee may exercise rights of inspection of all corporate books and records. Any stockholder may inspect the VTA. Any other stockholder may transfer his shares to the same trustee upon the same terms and conditions stated in the VTA and shall be bound by all the provisions therein. Okay? So take note, the requisites and limitations of this VTA must be in writing and duly notarized. Of course, gaya nga ng sabi ko before and gaya ng na-discuss nyo din sa oblikon nyo, kung na-discuss nyo ba, okay, mas proper ng mga agreements is in writing, okay, for you to have an evidence or proof na meron kayong agreement, diba? And much more, kapag notarized yan, it has the identity of a public document or public instrument, meaning hindi mo na siya kailangang i-present as executed with genuineness. Kasi genuine na yan because it is notarized. A certified true copy must be filed with the SEC. So yung VTA nyo must be filed with the SEC, yung certified true copy niya. Otherwise, it becomes ineffective and unenforceable. The voting trust shall not exceed 5 years at any one time, except if it is specifically required under a loan agreement, in which case the period may be for more than 5 years, but shall automatically expire upon full payment of the loan. So, ang term niya for one time is 5 years. Unless the voting trust is renewed Renewed, all rights granted in the agreement shall automatically expire at the agreed period, and the voting trust certificate and the certificate of stocks issued in the name of the trustees shall be deemed cancelled, and the new certificate of stock is issued in the name of the transferor. No VTA shall be entered into to circumvent laws against monopolies and illegal combinations in restraints of trade or fraud or for other purposes. So let me share bago tayo mag-stop bago tayo mag-end. Yung voting trust agreement na sinasabi ko, say for example, merong stockholder si Mr. A. Stockholder. Okay? Siya yung stockholder. Okay? Nag-enter siya into a voting trust agreement with Mr. B. Okay? Merong voting trust agreement. Okay. Now, yung sinasabi natin kanina dun sa lecture na transferor, si Mr. A yun. Siya yung stockholder. Okay? Si B naman, siya yung tinatawag nating trustee. Okay? Once they entered into a voting trust agreements which we either could be for a period of 5 years, okay, yung stocks na issued in the name of Mr. A, okay, yung stock certificate shall be cancelled. Okay? By virtue of this voting trust agreement, the stock certificate issued to Mr. A shall be cancelled. Instead, a new stock certificate shall be issued in the name of Mr. B. Okay? In the name of Mr. B. But in return, Mr. B shall issue a what you call the voting what do you call that na? Voting trust certificate. Okay? So, by virtue of this voting trust agreement, si B, siya na yung magvo-vote in behalf of A. Okay? With regards to their voting trust agreement. Take note na, voting trust agreement yan. Si B lang yung magvo-vote. So, ang sabi natin kanina, siya yung nag-acquire ng legal title with regards to the stock. Si A naman, ang meron lang sa kanya is equitable title. Okay? Yan yung voting trust agreement na sinasabi ko. With regards to expiration of this voting trust agreement, okay, pag nag-expire na itong VTA, okay, the stock certificate issued in favor of B shall now be cancelled. So, makakancel na ito. And a new stock certificate shall be issued in the name of A. So, dahil tapos na yung voting trust agreement nila, si A na ulit ang stockholder. Okay? With regards to the voting trust certificate, pag nag-expire na yung VTA, makakancel na rin ito. Okay? Yung legal title ni B, kasi nga nag-end na yung VTA, mapupunta na rin kay A. Bakit napunta kay A yung legal title? Because yung stock certificate na issue na rin kay A. Kaya siya legal title. Okay? Pero yung equitable title, wala yan. Hindi mo mapupunta kay B kasi trustee naman siya. Wala yan. Okay? So, yun yung voting trust agreement. Okay? Meron ba kayong questions? Questions? So, before we end? Nagpapakita ba yung PowerPoint sa inyo? Hello?
Yes, sir.
Yung sa iba kasi hindi daw nagpapakita.